On this podcast, I'm going to be discussing the Wisconsin Supreme Court case of McReath versus McReath. McReath is one of the more interesting and important cases to come down from our Supreme Court in quite some time, and it deals with the related issues of professional goodwill and what's known as double counting, or sometimes called double dipping. The issue involves when you have a professional business, how do you value the business, and the related issue of if you're valuing the business using the income from the business, are you using the same thing, the same asset, the same numbers, the same dollars, both for purposes of support and for purposes of property division? The controversy in Wisconsin on this started many, many years ago in a case called Holbrook versus Holbrook, where the Wisconsin Supreme Court affirmed a trial court decision that said that when Attorney Holbrook left his law firm, the only value he would receive would be his capital account. And therefore, in the divorce, the value of his interest in the law firm was limited to the capital account. Well, that made a whole lot of sense, because if that was all he was going to get in leaving the law firm, then why should his wife be entitled to more in the divorce than the value of what Attorney Holbrook would receive when he left his practice, or if he left his practice? That rule, however, seems to have been overextended, and courts have used that to say that Wisconsin did not consider professional goodwill to be an asset under any circumstances, even though it seemed to be an overreaching interpretation of what the limited holding of the Holbrook case was. And over the course of years, a number of other Wisconsin Court of Appeals and some Supreme Court decisions have sort of wrestled with it, to the extent that some cases have even ignored Holbrook altogether. When McReath came down from the Wisconsin Court of Appeals, it was the first case that created a holding that seemed significantly at odds with Holbrook and seemed to indicate that Holbrook is no longer good law whatsoever in terms of how it was interpreted. The McReath case involves an orthodontist, and in the divorce action, his interest in his practice was assessed that somebody would pay for the practice. Well, if you're buying an orthodontic practice, what are you buying? Well, you're buying, of course, the equipment, desks, and whatever they use, the pliers to get teeth out or straighten teeth, whatever it is that the orthodontists use. Maybe the accounts receivable, although if they're paid up, it's not going to have a significant value. And the primary thing that you're buying is going to be the ability of the business to attract customers who pay for services. Well, at the same time as valuing the practice by using that asset, the asset which is the ability of the business to attract customers, sometimes known as professional goodwill, the Mrs. McReath also won a very sizable maintenance award. On appeal, Dr. McReath argued that using that income for property division and valuing the business, and also awarding a sizable maintenance award, was double dipping or double counting, because you're using the same thing, in this case the ability of the practice to generate income, for two different purposes. One was for property division and the other was for support. The Court of Appeals affirmed the decision, and it seemed the Court of Appeals was mostly dealing with just the record in front of it and saying that under these circumstances the trial court only had the certain evidence put in front of it, and on that basis the trial court acted appropriately. In Wisconsin, of course, Court of Appeals are error-correcting courts. They don't set policy. So when the Supreme Court accepted review in the case, it seemed that it might result in a case which not only corrected any errors that the trial court made, if the trial court did make any errors, but could also review the policy in Wisconsin, not only in terms of professional goodwill and whether or not that could ever be an asset for property division, but also in terms of the law regarding double counting. The Supreme Court decision affirmed the Court of Appeals decision, and I'm going to look at it in both aspects because I think their treatment is quite different and leads to quite different results in how this is going to play out in the future. In terms of the first part, in terms of just the professional goodwill issue, the Supreme Court affirmed the Court of Appeals and said that where goodwill is saleable, it is available or included as property division for purposes of divorce. And that just makes a whole lot of sense. I mean, if you can sell it, then it has an asset value, and it should be included in the marital estate, assuming that it's not acquired by inheritance or gift from a third party. And under those circumstances, the trial court has certain discretion as what they might do or not do with it, but it's certainly includable. The circuit court, trial court certainly has authority to be able to divide it and include it in property division. And that part of the Supreme Court decision made a lot of sense, I think clarified a lot of Wisconsin law, and made it real clear that Holbrook is limited to the facts in front of it, that it dealt with that all Attorney Holbrook would get would be the capital account, and that was the value of his interest in the law firm, unlike Dr. McReath, who could sell his practice, receive a far larger number in terms of what he would get if he closed down his practice or if he sold his practice to somebody else, because it was saleable, it's includable, as opposed to Attorney Holbrook's, whose interest in his law practice was not saleable. That part seems to be rather obvious and is consistent with the law in most other states in this country which have considered the issue of saleable goodwill. The second part of it is the part that's more troublesome. In the second part, the Supreme Court says that the goodwill that was sold is not double counting with support that was ordered paid from Dr. McReath to Mrs. McReath. And I'm not sure the Supreme Court considered all the facts and circumstances involved in it. Probably the most important thing that the Supreme Court left out of their analysis at all is the concept of a covenant not to compete. I mean, if you're good, someone's going to buy a professional practice, and say, look at Dr. McReath's practice. Why would somebody buy that practice unless they knew that Dr. McReath wasn't going to open up his own practice under a different name next door? Because if they would, Dr. McReath notifies his patients, I'm no longer at wherever I was at, I'm not at this new practice, I've changed the name, but if you come in to get orthodontic work, I'll be the doctor who takes care of you. I think it's rather obvious that most patients' loyalty is to the doctor. It's not to the location. It's not to the name of the place. So if Dr. McReath opens up next door, that's where the patients are going to go. The way in the real world that's handled, if somebody's buying a practice based upon the ability of that practice to generate income, is they require Dr. McReath to sign a covenant not to compete. And that covenant not to compete has to be limited in terms of geography and in terms of time. It can't go on forever. It has to say within a certain geographical area, Dr. McReath cannot practice orthodontia for a certain period of time. And those limitations become very important here. That analysis is entirely left out of the Supreme Court decision. It's not even mentioned at all. And I find that real troublesome because it becomes associated with the value of the corporation, because absent signing the covenant not to compete, nobody's going to pay full value for Dr. McReath's practice, assuming full value means the ability to generate income, because you're not going to generate the income if the patients all go elsewhere. And on this, by the same token, if Dr. McReath does sign a covenant not to compete, what's his ability to will be to generate income? And if he doesn't have the ability to generate income, how's he going to pay support to Mrs. McReath? I'm not arguing one way or the other in terms of where the ultimate decision should come down. What I'm suggesting is that the Supreme Court really didn't consider the issue, and it may be because it wasn't presented appropriately in front of the trial court or briefed by the attorneys in front of the Supreme Court or Court of Appeals, but in any event, it's an issue that the Supreme Court, I feel, should have brought up on its own, because it's really critical to this analysis. If Dr. McReath is prohibited from practicing within a certain geographical area for a certain period of time, he can't generate income. Maybe he can get a job somewhere else, maybe he can't, it really isn't clear, but if he can't generate income, then how is he going to pay her support? And the double dipping issue is a real simple one. It's if that same income is used for both purposes, he has to have the ability to A, sell the practice where the purchaser is going to be buying it for that income, and B, generate that income without violating a non-compete agreement. Maybe he can do it, maybe he can't. It just isn't clear from the record, and I find it troublesome in the decision that it isn't clearly considered by the Wisconsin Supreme Court. So where are we left after McReath? Well, on the one hand, we seem now to have a fairly clear law in Wisconsin that trial courts in divorce actions can include saleable goodwill within property division. Consistent, as I said, with other states, and it's consistent with other Wisconsin law that says if something can be sold, it is potentially an asset, potentially available for property division. The second part of it becomes more difficult because the law regarding double dipping or double counting is much more complex than the law regarding just simple saleable goodwill. In the course of this podcast, I'm not able to give a complete analysis of that. I did write an article for the Wisconsin Journal of Family Law that discusses some of the distinctions historically in Wisconsin double counting, and also the types of cases that have dealt with double counting and how the analysis differs. You'll find that article if you go to the section of our website that says articles, and it's entitled "An Asset So Nice It's Counted Twice," printed in the Wisconsin Journal of Family Law, and that provides a far more in-depth analysis of the issue of double dipping and double counting than I'm going to be able to give you in the course of this podcast. So that issue is still a troublesome one in Wisconsin. I think it's still open for argument before a court in an appropriate case, but I think it's unfortunate that the Wisconsin Supreme Court didn't give it more guidance in terms of how to handle that in future cases. We may have to wait for another case to do that. It's been, I don't know, 7, 8, 9 years since the last double counting case before the Supreme Court, so it might be quite some time before we get any clarification after McReath. But that's where we are so far, and something we'll be having to deal with here in Wisconsin for the next number of years. Thank you.